Hey everybody, Matt Johnston here, Matt the Lawyer. It has been a hot minute, as my children would say, since I've done one of these videos. So I wanted to tell everybody about the big news. Yesterday was not a great news for small business employers out there. The Federal Trade Commission and the Department of Labor issued new rules that are going to affect the way small businesses do their or manage their relationships with their employees. The Federal Trade Commission issued a rule, or voted to issue a rule, that would ban non compete agreements for pretty much everybody in the United States. This ban is one of the efforts that the Biden administration is undertaking in order to increase competition. At least that's the plan. Federal Trade Commission Chairwoman Alina Khan has been a longtime student of non-competes. It's something that she's done in the academic world. And since her tenure has begun at the FTC, she has undertaken a number of initiatives in order to reduce the effect of non-competes. So the non-compete rule will take effect in about 120 days. The rule will take effect 120 days after its publication in the Federal Register, which I expect will be sometime in the next couple of weeks. Effectively, no new non-competes can be entered into between an employer and any worker. Now, here's the thing that we need to make sure everybody understands. Worker is not just defined as employee. It includes independent contractors. So anybody who does work for the company, whether as an employee or as an independent contractor, cannot be subject to a non-compete ban. So what does that mean? Well, that means that anybody who you have on a non-compete currently, or anybody that you previously employed that is still subject to a non-compete, you have to provide notice to those particular employees and independent contractors that you will not be enforcing the non-compete provisions in that contract. So let's say you had a former employee who has left, is still subject to a non-compete for maybe another 6 months or so. You have to provide a notice, and there's sample language in the statute. If you check out my blog in a couple of days, I will have that sample language up. You send that sample language either by mail, email. In theory, you could send it by text, but you have to provide some notice that you will not be enforcing the non-competes. Now, there is one small carve-out out there, and that small carve-out is for senior executives, so current senior executives, who are making at least $151,164 per year. That's the minimum salary. If they are making that amount and they're a senior executive, then the current non-compete that they have can be enforced. Finally, if you are a franchisee, so non-competes between franchisees and franchisors are not affected. And similarly, if you sell a business and as part of the business there is a non-compete provision, that provision is still enforceable and still legal. So to quickly summarize, in roughly 120 days, no employer will be able to enter into a non-compete agreement. And there are a few small carve-outs. Non-disclosure agreements and non-solicitation agreements are still legal. However, if they have the effect of forcing somebody to not be able to work for a particular company or engage in their particular trade, then those two would be banned. So already somebody has filed a suit. I saw the notice last night that I believe it's an accounting firm in Texas has already filed suit on this law, which means they've been waiting for the Federal Trade Commission to issue their rule. The U.S. Chamber of Commerce has also threatened lawsuits, so I would imagine this is going to be a deeply litigated piece of legislation, or piece of regulation rather, and it will be interesting to see what happens. But for now, I think small employers are going to need to start taking steps to move away from non-compete agreements. I do think, well, first of all, the trend is already in that direction, but I think that it's going to be a wise step to start looking better at non-disclosure agreements or non-solicitation agreements as part of your sort of restricted covenants with, particularly with senior employees. All right. The other thing is much more of a direct effect, and that is the Department of Labor issued its final rule on changes to the overtime regulations for the most common exemptions under the Fair Labor Standards Act. The most common ones being the executive, administrative, and professional rules, along with computer professionals and outside sales professionals. This rule's been coming for a while. It shouldn't be any surprise, but the way the structure is set up is important for people to understand. The new rule will take effect on July 1st, 2024. And before that rule, the minimum salary level per week is $684 per week. That comes to $35,568 per year. So that's the current rule that will be in effect until July 1, 2024. Starting July 1 and going through to December 31 of 2024, so a 6-month period, the salary level will increase to $844 per week. That is $43,888 per year. So below that level, anybody making below that level will not be considered exempt. Unless one of the other, almost 24 exemptions apply. But the most common ones being executive, administrative, professional exemptions. That's going to be the new salary level. There is an exemption for highly compensated individuals. These are typically your very senior executives, things like that. If they are making at least $132,964 per year, of which they receive at least $844 a week in a fixed salary, then those highly compensated individuals will be considered exempt from the minimum wage and the overtime rules. So that's the rule between July 1 of this year and December 31 of this year. Starting January 1, 2025, the salary level will increase to $1,128 per week. That is an annual salary of $58,656 per year. So again, anybody who is making less than that amount as a weekly salary is not considered exempt based upon the salary level. Has absolutely nothing to do with their job duties. They simply aren't making enough money. The highly compensated individuals will have a number that seems slightly familiar. You may have heard this one, and that is the $151,164. If that's the annual salary for a highly compensated individual, then they will remain exempt under the overtime rules. The new rule also has an automatic recalculation date set forward to happen every 3 years. So July 1, 2027, and then every 3 years after that, the minimum salary level for exempt individuals will be set or reset according to a formula that essentially looks at the 35th percentile of salaried employees in the United States. It's going to be the 35th percentile of that, according to the Bureau of Labor Statistics. So they're going to have some automatic recalculation. I don't think this regulation is going to see as much litigation. There may be some, but I seriously doubt there's going to be any significant litigation, and I don't think much of it's going to be very successful. The Department of Labor sort of learned its lesson from the Obama administration's sort of failure to really sort of ramp up and manage things. So the DOL has done a pretty good job of putting together this regulation with a minimum of fuss. So I think this one is not going to see as many robust challenges as the Federal Trade Commission rules are concerned. So what does this mean for small businesses? Well, the salary level is going to be something that individual companies are going to have to take a look at, particularly for currently salaried employees. And you need to figure out, well, if we leave them at their level now, how much work do they do that is more than 40 hours a week? Can they do their job within 40 hours a week? Would overtime kill us if we had to suddenly pay somebody overtime for 1 or 2 hours in a week? If the answer is the employee does a lot of time working over 40 hours in a week to get their work done, you're either going to need to restructure their job or you're going to have to increase their salary. And you'll have to do a couple of steps. You're looking at roughly $8,000 between now and July 1. And then you're looking at, almost $12,000 from July 1 to January 1 of next year. So you're looking at a very significant, almost $13,000, $14,000 increase in salary for some workers if you want to maintain them on a salary level. So if you are an employee or employer who's going to have a lot of these employees who are going to be caught up in this, now's the time to start working on your policies, your pay policies, job descriptions, and things of that nature. If you want to set a consultation, please do so. You can go to our website, mattthelawyer.com, and in the upper right-hand side, there's a link there you can use to schedule a consultation. I will have additional blog posts on this as I get around to getting them written. I spent much of the evening last night and this morning reading these rules and getting this information prepared for you. If you were a small employer, yesterday was not a great day in terms of labor regulations, but there is time to start to manage some of the change that is going to be necessary. In the meantime, I hope everybody has a great day. Go out and watch some live soccer. We will talk to you later. Bye-bye.